Morning, sir. The Reggie Limantas about Criminal Procedure Rule 110, Prosecution of Offenses, Section 1, Institution of Criminal Actions. This section states that as offenses outside Metro Manila then has more than 6 years and 1 day, punishment should require preliminary investigation, while if the offense punishment is less than 6 years and 1 day, the complaint or information should directly filed with the municipal trial court or municipal circuit trial court and face of the prosecutor of offenses in Metro Manila and the other charactered cities. The complaint information should be filed office the prosecutor. In the section 2 of the Rule 110 stated that the general requirements of complaint or information are first shall be rating. Second, the name of the people of the Philippines, and third is again of person. All persons who appear to responsible for the offense involved. The section 3 of this rule defines the complaint, which is a sworn written statement charging a person with the offense subscribed by a OPP of the offended party. Peace offer or the public officer charged will be enforcement of the law violated and failed the prosecutor's office. While Section 4 of the Rule 110 defines information as RAS, accusation is writing charging a person an offense subscribed by the prosecutor and filed with the court. According to the section of 5, Rule 110, public prosecutor shall prosecute the criminal actions. That is the general rule, but has exemptions. Exemptions where a private prosecutor can prosecute the criminal action when the case heavy work schedule of the public prosecutor or in the event of lack and public prosecutor. But even though those circumstances are present private prosecutor can prosecute the criminal actions unless he or she has an written authorization by the chief prosecution office and should have the approval of the court. The second paragraph of this section stated that the private crimes, adultery, and concubinage shall be prosecuted only in the offended spouse will fill the complaint or information. And in third paragraph are offenses of the seductions, abductions, and act of lasciviousness shall only prosecuted if the complaint or information was filed by the offended party or parents, grand and parents, guardians, and state. The offended party should exercise the right or failing successively. In Section 6 to Section 12 of the Rule 110 states the sufficiency of the complaint and the information should states in the accused the designation, the offense given by the statute, acts of omissions. Complaints of instituting the offense, the name of the offended party, and approximate date of the commission of the offense and the place where the offense was committed. The general rule of the duplicity of the offense and Section 13 of the rule is that the one information is the equal to offense. Exception is the law prescribes a single punishment for various offenses. Rule 111. Prosecution of the civil action according to the Section 1 of this rule, when criminal action is instituted, the civil liability shall be deemed instituted. That is the general rule, but there is an exemption first when the offended party waives the civil action. Second, the offended party reserves the right to institute it separately. Always remember that reservation shall be made for before prosecution as starts presenting the evidences. And the third is institutes the civil action prior to the criminal action. But always remember the primacy of criminal action over civil action, that even the civil action is instituted first man the criminal actions. The civil action shall be suspended until final judgment and rendered in the criminal action. In the exchange situation, when criminal action is the institute first then civil action, still the civil action is suspended and after final judgment rendered to the criminal action. Next, Rule 112 and the preliminary investigation. According to Section 1 of this rule, preliminary investigation is an required proceeding to determine whether there is a probable cause in the name that the crime has been committed. The preliminary investigation is required to be conducted before filing a complaint or information for offense where the penalty prescribed by law is at least 6 years and 1 day imprisonment. The, the officers allowed to conduct preliminary actions. Preliminary investigations are the provincials or city prosecutors and their assistants, national and regional state prosecutors, and others and other officers, and may be authorized by the law, such as Comelec and Ombudsman. Rule 113 is arrest. Arrest is the arrest is the taking of the person into custody in order that he may be bound the answer for the commission of an offense. An arrest made by an actual resident of a person to be arrested, or by his submission into the custody to the person making the arrest. It shall be the duty of the other executing of the warrant of the arrest to accuse to and deliver him to the nearest police station or jail without unnecessary delay. In Section 4, Rule 113, the warrant to be executed within the 10 days from its receipt. Within 10 days after the expiration of the period, the officer shall make a report to the judge, and in case of his failure to execute the warrant, he shall state the reason. Section 5 of the Rule 113. A peace officer, a private person, allows to arrest a person without a warrant, with one the person to be arrested has committed, actually committing or attempting to commit or offense and in flagrante delicto, to have probable cause to believe an offense and just been committed. Hot pursuit. 3. And a prisoner who has escaped from a penal establishment, escape prisoner. An arrest may be made in any day and any time of the day or day. In Section 11, police officer must identify themselves and announce their purpose before using force to enter. Apply first the break and announce doctrine. The rule 114 is bail. According to the Section 1 of this rule, bail is a security given for release a person in custody of the law, furnished by the bondsman to guarantee his appearance there before in any court. Bail may be given in form corporate, surely property bond, cash deposit, and recognizance. According to the Section 2 of this rule, all persons having an offense can avail bail except those charged with offenses punishable by reclusion perpetua, death penalty, and life imprisonment. According to Section 4 of Rule 114, bail is a matter of right when, before, and after conviction for the trial municipal court, metropolitan trial court, and municipal circuit trial court, and before conviction by the regional trial court of the offense not punishable by LDR. Well, according to Section 5, this rule bail is a matter of discretion when upon conviction by the regional trial court of the offense not punishable by LDR and also punishable by LDR is the evidence is guilt and not strong. Rule 115, the rights of accused. The accused criminal prosecutions has several rights, including the first, presumption of the innocence. Second, right to be informed of the nature and cause of the accusation. Third, the right to the present and defend themselves. Fourth, and right to waive their presence on the trial unless physically ordered by the court. And the fifth is the accused can be testified the witness on their behalf. And six, can confront and cross-examine witness against them. And speedy, impartial, and public trial. And 8, accused can appeal in all cases allowed in the manner prescribed by law. Rule 116, arraignment and the plea. According to the paragraph of of Section 1 of this rule, the accused must be arraigned before the before the court where the complaint information was filed or the sign of trial. Arraignments shall be made in open court by the judge by the giving of accused within a copy and the complaint information, reading the name, reading the same dialect done by the accused as asking him whether he pleads guilty or not guilty, and accused answers the plea. Paragraph B stated the accused be presented an arraignment that must personally enter his plea. According to the paragraph C of the section 1 of this rule, one, if the role of the accused refuses plead and a plea not guilty shall be entered for him. Deemed in paragraph D when the accused plead guilty but presents exculpatory evidence, this plea shall be deemed withdrawn and plea if not guilt shall be entered of him. Rule 117 is the motion of to quash or the request for dismissal. In section 1 of this rule, accused may be moved to squash of the information or complaint any time before entering his plea. The motion of squash shall be a writing signed by the accused of his counsel and shall distinctly specify its factual and legal grounds. According to the section 3 of this rule, there are only 9 grounds that the accused may move to quash the complaint or information. First is the facts charged do not constitute an offense. Second is the court trying the case has no jurisdiction over the person of the accused. That the court trying the case has no jurisdiction over the person of the accused. That the officer who filed the information has no authority to do so. That is not conformed substantially to the prescribed form, duplicity of the offenses, that the criminal action or liability has been extinguishes, that is contains avertisement, which is the true word constitute of legal excuse or justification unless is double jeopardy. After entering the plea, the accused can still file motion to squash a ground A, B, G, I, or grounds on 1 to 7 and 9. Rule 118, pre-trial. Rule 118, pre-trial. According to the section 1 of this rule, pre-trial is mandatory in criminal cases. It is conducted to avoid surprises during the pre-trial. Both parties will lay down evidences and witnesses because failure is not present on the pre-trial. It could be not admitted during trial unless otherwise. The reason for that is the good cause, and the case there is objections, it will be raised that is the reason why there is a pre-trial. In pre-trial, there will be plea bargaining, stipulation of facts may marking for identification of evidence, whether of the objections to admissibility of the evidence and modifications of the order of the trial in the accused admits the charge. In Section 2 is stipulated that all agreement on or admissions made or entered during the pre-trial conference shall be reduced and writing and signed by the accused and counsel, otherwise they cannot be used against the accused. The non-appearance, the accused and the counsel, the court may impose proper sanctions or penalties. Rule 119. Trial according to the section 1 of this rule, the time is to prepare trial to after plea. Not guilty is entered, and the accused shall have 15 days to prepare of trial. Then the trial shall commence within 30 days from the receipt of the pre-trial court. On Section 3 of the period of delay shall be excluded, computing the time within delay resulting from other proceeding. Concerning the accused delay resulting from mental incompetence or physical inability of the accused to stand trial if the information is dismissed upon motion of the prosecution. On Section 11, the order trial was the first, the prosecution shall present evidence to prove the charge. Then the accused has the evidence as the offense that to defense present rebuttal and so rebuttal evidence that shall be deemed submitted for decisions. Section 17 is the discharge of accused to be state witness happens that there is no stronger direct evidence. The prosecutor will select one of the suspect to be a witness, but he or she not appear to the most guilty. Section 23, the demurrer of evidence. It was after the prosecution raised its case, the court may dismiss the action of ground and the insufficiency of the evidence. Rule 120, judgment according to the Section 1 of the rule. Judgment is the adjudication of the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability. Rule 121, the trial of reconsideration according to the Section 1 of this rule, the time for new trial, the reconsideration at any time before a judgment and conviction becomes a final. Section 2 is the most ground for the new trial. First is the errors of law, and second, the law new the materials evidence has been discovered. Rule 122 in the appeal. According to Section 1 of the rule, any party may appeal from the judgment or final order unless the accused will be placed on double jeopardy. Section 2 is where to appeal where the first level court or MTC appeal to RTC when the RTC appeal on Court of the Appeals and win from Court and appeals P in Supreme Court. Rule 123 is the procedure in the Municipal Trial Court. Rule 124 is the procedure of the Court of the Appeals, and Rule 125 the procedure of the Court Supreme Court. Rule 126 the seized and seizures section define a search warrant as an order of writing the name of the people of the Philippines signed by the judge and directed to place of officer commanded to him to search for personal property described therein and bring it before the court. The personal property to be seized according to the Section 3 are subject of the offense, embezzlement, property and use the intended to the use and the mean on committing of offense. Section 7, search warrant shall not issue except upon the probable cause in the connection with one specific offense to the determined personally and by the judge be found in Section 4 of Rule 126 in the Section 7. Police officer must identify themselves and announce their purpose before using force to apply first the break and announce doctrine. The warrant must be served that day unless the affidavit indicates the property is on the person or place. In case it can be served at any time of the day and night found in Section 9. Thank you, sir.